Hello, this is Ann Seurynck, and I am also joined by Laura Genovich, who will be speaking later, and we are presenting a webinar on millages. And as you can see, it's from ballot language to the ballot box. This is an election season. It's an election year, and because of that, we've already seen an increase in the typical amount of millage proposals that people are putting on the ballots for, even for May, but also for August and November of this year. So this is something that it's a good time to talk about what has to be in the millage language and what you, kind of the do's and don'ts of advertising for that millage, what a public body can do and what they can't do with public funds. And that's going to be the primary focus of this presentation. There is an ability to ask questions. There's a box that you can ask questions, and we will do our best to answer them. At times it's very difficult to do that during the presentation, and if we don't, we will get back to you after the webinar with a response. So please feel free either to post a question in the box or to send either Laura and I an email. And as you can see from this slide, the email addresses are included in on the first page and the last page of the slide. One of the things that we ask our clients to focus on is, when you get started, what authority do you have to request or levy a millage? And you have to be very careful, because typically for financial matters with public bodies, you have to have specific authority to spend money or specific authority to levy a millage. This authority can come from a variety of sources. It can come from statutes, can come from the Constitution. If you are a city, the city charter often has provisions of and limits to the ability to levy a millage. So before you even ask the public for funding for a particular proposal, make sure you discuss with your attorney the authority for that, to make sure that you do have proper authority to present that proposal to voters. One of the other issues is sort of the pre-planning stages. One thing that you need to do before you present to voters or present and provide your attorney with information to draft the millage proposal is determine how much you will need. Obviously the millage and the property taxes is the primary source of the funding, but if you have other state funds, gifts or endowments, private donations, general funds, those should all come into play and should be considered and discussed prior to asking for a millage proposal. And at the very least, you may have questions in the end from your constituents as to why you ask for that much, especially if you're raising a millage. So you want to be able to have the information in front of you that shows what your revenue sources are, what you had available from other sources, and why you decided to ask for that particular millage amount. So Michigan law has very specific requirements for ballot language, and even with that, if you Google or take a look at ballot proposals across Michigan, a lot of their elements are the same, and a lot of them have some slightly different language used. But I want to give you the specific requirements of the statute so that you can understand what information has to be conveyed to voters in a ballot proposal. And the law was significantly changed. It's been a while now, Public Act 248 of 1999. And I point this out because I often have public bodies tell me that they just want to change the numbers in their old ballot language. Some of these ballot proposals are old. They're expiring after 20 years. They predate this 1999 Public Act. So be very careful about just using old ballot language, because it may not be sufficient for a 2016 or beyond election. So one of the first things that you need to discuss is the millage rate to be authorized. The millage rate to be authorized is amount expressed in the term mills. A mill is 1/10 of a cent. So in millage language, the public body describes the mills in terms of how much it will levy per $1,000 of taxable value. So you have to make sure, you have to do it both with the written word and explaining what the numbers would be. So example, one mill is $1 per $1,000 of taxable value. And it is taxable value and not SEV or assessed value, so taxable value. A half mill is 50 cents per $1,000 of taxable value. Again, if you are using old ballot language, which we don't recommend, make sure that the written description matches the numbers before you present it to voters. And we often use an amount not to exceed to allow a public body to levy a lower amount. I think this is sort of implied, and we take the position as who's really going to complain if your ballot language says that the township shall levy 1 mil for fire service and the township decides 1 year it only wants to levy 0.9 mil. Likely you're not going to get any challenges, but just to be sure, we recommend using the language, quote, in an amount not to exceed. Therefore, that gives complete discretion to the public body on an annual basis of how much they want to levy. The ballot language must also include an estimate of the amount of revenue that it will be collected in the first year of the millage as levied and authorized. Again, this is expressed in the terms of taxable value. You have to consider the year in which this will be first levied and authorized. And this was, I think, more of a challenge prior to 2008 because property values had been going up. And if you decided to renew or ask for a millage but not levy it for a few years, you had to keep in mind that at some point the property values may, if you get an estimate that, in your particular community they would raise, they increased about 4% every year, you'd want to make sure you accounted for that in your estimate. Again, this is just an estimate of revenue. It's not an exact science, and I've seen a lot of ballot proposals that'll have the estimate down to the, down to the cent, and it doesn't necessarily have to be that specific. It's going to, obviously things will impact the amount of revenue that you will be able to collect in every year. If people don't pay their taxes, or if the county has a lot of delinquent taxes, that may affect the ultimate and the end amount you will receive. So again, it's just an estimate. But you want to be careful because, if you estimate that it will raise, $500,000, or it's really going to raise $750,000, then there may be a problem with what information was provided to voters as far as that ballot proposal. Duration in the millage of years, and if I was going to pick a point that you should really be concerned about, it would be this, because this is I think the single biggest mistake I see on ballot proposals. Because it doesn't seem, the actual duration of the millages seems like it should be, you should just add 20 years to the first year of levy, but that's not the case because you have to count the first year and the last year. And I'll give you the example. We recommend using numbers and dates, for example, for a period of 20 years, 2016 to 2035 inclusive. It's not 2036 inclusive, although 20 plus 2016 is 2036. That would actually be a 21-year levy. Be very careful, and if you haven't pulled your old ballot language out and you have a 20-year millage that's in year 15, 16, or 17, pull it out and take a look at it again, because we've seen some of the older ballot proposals have this mistake on there, and you may actually end up not being able to levy that last year if if you had a 20-year millage but the dates were for 21 years. So be very careful about that. That may impact when you go for a renewal. It may impact your finances. A lot of public bodies are limited by the Constitution to levying a portion of or all of their millage for a maximum of 20 years. Other millages may be limited further by charter. There are some entities that are actually able to levy millages in perpetuity, and that's because their authorization predated certain laws that prevented these longer millages. These millages in perpetuity, but there's specific statutory authority for these millages in perpetuity. For example, district libraries. I know some of you attending our district library representatives. District libraries can levy up to 4 mills. 2 of those mills can be in perpetuity, and 2 of them are maxed out at 20 years. Similarly, township libraries, for example, can levy up to 2 mills, and they can levy those in perpetuity. But again, ask your attorney for assistance regarding those limitations on the millages to make sure that you have the proper statutory authority. And again, check and recheck your old ballot proposal. One thing that we, as a practice pointer, if you're having your attorney draft ballot proposal, send them your old ballot proposal. Make sure that they've looked at what you've done before, because it can come into play in a couple different ways, and one of them is the duration. Consider the year that the public body desires the initial levy. And you have to give an example of that. They sometimes communities want to ask for a millage renewal to give them a little bit of cushion. So, for example, if the last authorized millage will occur in December of 2016, sometimes communities want to go for that renewal in 2015 or 2016 to make sure that they're not down to the wire in 2017 when that new ballot proposal will be when they will really need that new authorization. So, for example, you want to make sure that you have that initial year of levy and that you don't skip a year. So, for example, if your last millage had a 2016 end date, you want to make sure that the new millage starts in 2017. And again, verifying what is included on your old ballot proposal will be very important. And this slide provides an example where if the public body decided to hold an election in November of 2016 to vote in a 10-year millage, and they could still levy their old millage in 2016, the initial levy will occur in 2017, and that's what should be included in the ballot proposal. One thing about the first year of levy, there's a couple things we want to point out, and it's a little bit more tricky for authorities than it is for cities, townships, and villages, because cities, townships, and villages typically know when you levy a millage. Some cities, for example, are required by charter to levy only in the summer. Most townships levy in the winter. Keep this in mind if you are an authority, such as a district library, recreational authority, or other authority that may include both cities and townships, because you may have a situation where a city has to levy their millage in July and a township has to levy their millage in December. A district-wide millage has to be levied uniformly in a calendar year. So that has something that you know we make a point to talk about with clients. But if you are that type of entity and you have 2 different times where your tax bills go out, make sure that you time your renewals in a way that you're not trying to straddle over 2 different calendar years. The L-2049 form, and I know many of you fill that out and understand that it's due to the county by September 30th each year, but there is a provision in Michigan election law that if you hold your millage election in the November general election, it allows local units to levy the millage in December of that year. However, you should consult with your attorney and the county to verify that your November millage will be included on that December tax levy. And please, please verify that the county has received it and that the tax bills will go out with that millage on there. Otherwise, you will likely lose a year of your millage and you put yourself a little bit behind as far as that goes. So again, make sure when you're in your pre-planning stage to figure out if you went on a certain election, could you levy that entirely in your district or your community in that year, or what year should be the first year of the levy. The ballot language must also include a clear statement of the purpose of the millage, and this is the part I think that a community has the most discretion. It's also one of the most important parts of the ballot proposal. Michigan law has a long-standing provision that states funds raised from a millage may not be used for any other purpose other than that specifically set forth in the ballot language. So be careful of how you describe the purpose and make sure you describe it sufficiently so that you may use those proceeds accordingly. I'm going to give you a couple of examples. So we want to use money to operate a new township hall, but our ballot language only provides money for the construction of a new building. Can we use the money for the operation of the new building? Use of those funds could be subject to challenge. The ballot proposal specifically said all more money was going for the construction of the new building. So what happens if you have excess money? Excess money would have to be held in escrow for use permitted under the ballot language. It could not be spent in a way that was contrary to what was in the ballot proposal. So the fix to the problem in your planning stages anticipate other uses. So, for example, if you wanted a millage and the millage was supposed to be for the construction and operation, make sure that the millage language says something, for example, like constructing, equipping, and operating the building. This is one of those areas I like to flag with people who have what we call operational millages, and a lot of old millages are for the operation of a particular entity. And I typically like to be a little bit more expansive, only because operation, I think it begs the question of whether it could be used for capital improvements. Now, I haven't seen any case law or any AG opinion interpreting that issue, but I think as a matter of thinking ahead and thinking about your ballot language, you should be making sure that you incorporate all intended uses or all intended purposes. Another common problem, 2 years ago the voters approved a millage for 10 years to operate the John Doe branch of the Newtown District Library. Now they're considering closing the branch. Can we use the millage funds for other library purposes? Again, the public body may be subject to challenge if the money is used for other purposes other than the John Doe branch. Again, to fix the problem to make the language more general. For example, to operate any branch of the Newtown District Library. There's a flip side to this, because I've basically been talking about how to make the language more expansive. A couple of ways we do that is with, for example, with the district libraries. A lot of the district library millages that we draft state that the ballot on the ballot proposal that it should be for all district library purposes authorized by law. It's very general. For police and fire, oftentimes we say for operating, equipping, and constructing the fire department, for example, and all other fire department purposes provided by law. If it's for fire and ambulance, it should say for fire and ambulance. If it's for police, it should say for police. Now, there are circumstances in which a community wants to be very pointed in what they ask for. And I've seen some of these. They ask for money to increase the funding or increase the amount of police officers in the township, for example, or in the city. Now, there's nothing wrong with that. You just have to be very careful on how you use that money. That money should be put in a fund that is earmarked for that purpose. The other issue is with the renewal, and with the renewal you want to make sure that the purpose is broad enough so that if it's renewed, you are consistent with how that renewal will be put before the voters. So another common problem, we just asked voters for an operating millage last year, but the money's not going to be enough and we have to reduce the police force. Can we ask for an additional millage to spend for police protection? Again, in this example, you asked for a general operating millage last year, and now you're asking for a new police millage. The answer is yes, as long as you're still within the authorized amount and you're not bumping it up against any of your constitutional limitations on total taxes. But again, the money can only be used for police protection. A clear statement indicating whether the proposed millage is a renewal of a previously authorized millage or an authorization of a new additional millage. The way we draft this is we either say it's a renewal or we use the term, quote, new additional millage, and that's the only two ways we describe it. I've seen other proposals that talk about increases and other descriptions, but to me, this is right. The italicized language here is right out of the statute. A clear statement indicating whether the proposed millage is a renewal or an authorization of a new millage. There's basically two choices. The renewal, in order to call it a renewal, and I have a lot of communities because wanting to fit into this definition of renewal. And obviously that's because they want to make sure that their voters understand that it's a continuation essentially of a millage that they're already paying, and they're not going to be seeing a huge leap in taxes. That's one reason a lot of communities want to characterize it as a renewal. But you have to be very careful. The statute was the way it was. The statute was worded in a way that it made it very clear, but then the Attorney General issued an opinion that solidified the interpretation that we're going to explain here in our presentation. So a renewal must be a true renewal of the millage as last levied. So if the voters authorized 1 mil years ago, but it's now been reduced to 0.87, you can only ask for a renewal of that 0.87. So the millage continues to be reduced along those same lines by the Headley Amendment and doesn't get bumped back up under the term renewal. To restore the full mill, the voters must also be asked for an additional new millage of 0.13 mil. So a new millage is any millage that's not a renewal. So how do you handle this? A couple ways to do this is, and we'll get into a little bit later, but you can, assuming that it doesn't exceed the 0.5 new millage statutory limitation, you can ask in one question for the voters to increase the millage, for example, back to 1 mil, and we say something like, shall the township be authorized to levy 1 mil, of which 0.87 is a renewal of previously authorized millage, and 0.13 is new additional millage. Sometimes we even indicate that it's new additional millage to basically recapture or to get back the amount that's lost due to the Headley Amendment. So there's a couple ways you can do that. Some communities just opt not to ask for any of they want it to be a true renewal, so they'll give up that slight loss that they have due to the Headley Amendment. Others want to get bumped back up. Sometimes people take it as an opportunity to even further increase the millage. And all of those should be reviewed by your attorney to make sure that it satisfies the statutory requirements and you're not exceeding any of the maximum amount you're authorized to levy, either as a renewal or a new millage. So this is probably the most unpopular part of the ballot proposal. And the ballot has to fully disclose each local unit of government to which revenue from millages will be dispersed. And I think this is the provision of that quote-unquote new law that was the slowest to catch on. And those of you that have been paying attention, I think, back in 2001, 2002, very few ballot proposals were indicating what local unit of government would actually receive revenue from this millage. Local unit of government is defined as a city, county, village, township, school district, intermediate school district, community college, public library, other authority created under state law. This would include any authority such as a DDA, LDFA, brownfields. There's also, since 1999, there's a number of new authorities that have the ability to capture, like corridor improvement authorities, water resource authorities. So there could be a number of different entities which capture your millage. You should be able to get a list of those if you don't have them from the county. But you have to disclose to each local, you have to disclose each local unit of government to which revenue from that millage would be dispersed. So the way that's handled is typically there's a provision at the end of the ballot proposal that says, you know, a portion of this, of the revenue may be required to be captured or dispersed to the DDA or the LDFA. So this has become a problem, I think, for some communities where they have a large territory and a number of DDAs, and it can look sort of overwhelming on the ballot proposal when you have to list, you know, if you're a county and you have to list 20 different DDAs that are going to capture your millage. This happens also quite frequently with large district libraries, for example. They have to notify them of, you know, a number of different authorities. And at first I think that this caused a lot of problem and confusion among voters. I think voters now are more sensitized to this. They're used to seeing it on the ballot proposal. They have come to understand a little bit more about what it means. But when you talk about advertising or explaining your ballot proposal, this is one of those issues that I think bears some pre-thought, because typically you'll have a couple people approach you and ask, why is this in there? What does this mean to us? And why are you telling us this? And simply put, from the newspaper articles that were describing why this was developed in 1999, it really was because one of the local legislators did not realize that when he voted for a millage proposal that some of it was going to funding other units of government. That, you know, if he voted in a library millage, it was going and it was captured and used by the local downtown development authority. He thought voters should know that. So regardless of how your personal feelings about that, that is the law. It's remained the law now for over 16 years, and so hopefully it's not becoming a problem, or it's becoming less of a problem, and people just understand that those are the necessary disclosures. So again, voter education is very important with dealing with this issue. So I alluded to this earlier, but one of the issues is, you know, do we need one or two questions? And this is the law, is that a taxing unit that levies a millage shall not submit a single question to the electors requesting both a renewal and the authorization of new additional millage if the new additional millage is greater than 0.5 mils. So I'll give you a couple examples. The renewal of a millage that includes a Headley rollback. If your public body previously approved 1.5 mils for 20 years and expires, and you currently levy 0.97 mils, can you ask for a renewal and a new millage of back up to the 1.5 and one or two questions? Two questions are needed in this example because the public body must ask for a renewal of 0.97 mil and a new additional millage of 0.53 mil to recover the amount lost to Headley. Since the new additional millage exceeds 0.5 mils, two questions are required. So again, another example, if the public body desires to ask voters for renewal of the millage and new millage at the same time, in this example, if it was 1 mil that's been reduced by Headley to 0.9 mil, the public body can ask voters to renew the 0.9 mil and approve an additional 0.1 mil in one question, since the new millage is less than 0.5 mil. We see a lot of communities that are actually using this 0.5 mil and asking voters for new additional mil of 0.5 mil just to get the maximum amount they can do in one question. I think anecdotally there's been some cases where, you know, if there's a renewal and a new millage, the renewal will pass, but the new millage won't pass. And I don't have statistics, obviously, for each of your individual counties or areas, but that's something to consider and to look into before you decide whether or not you want to go for one or two questions. And also, in my opinion, for example, if you are facing this issue and, for example, in the prior example, you wanted to get back up to 1.5, I've seen nothing that precludes you for asking for that 1.5 as all additional new millage. The only restriction on this 2 questions is if you ask for a renewal and a new millage in 1 question. So if you characterize it all as new millage, that can be done in 1 question. But again, it's something that you should consult with your attorney on to make sure you've got the proper wording and proper facts, the proper analysis for your particular fact situation. So for ballot language, the public body must adopt a resolution to place the millage question on the ballot. And only 2 millage elections can take place typically within 1 calendar year. Again, cities, villages, and township, please verify that your proposed election date is permissible. You can ask for, I want to be clear about this, you can only go ask voters twice a year for millage proposals, but you can have as many millage proposals on the ballot as you want. So for example, you couldn't ask for fire millage in May, road millage in August, and police in November. But you could put all 3 of those ballot proposals on the August election. So again, it's the amount of time that you have, the number of elections per calendar year that you can put proposals on the ballot, but you can put as many on 1 election as legally permissible for your particular situation. Important election dates. We used to have to prepare election calendars and count the dates and recount the dates, but the State Bureau of Elections has done a fabulous job of printing out election calendars. Make sure that you take a look at that election calendar. Also make sure that you verify that date with the township, county clerk, whoever you have to submit your ballot proposal to. And the reason is you don't want to have a miscommunication on dates. Often the miscommunication happens where they require you to have something earlier than you're required to. For example, there's a requirement to have a petition to place a local proposal on the election, and that petition is typically due 2 weeks before the ballot proposal language are. So I've had some clerks inform municipalities that they've missed the deadline because the petition deadline is passed. The petition deadline is different from the ballot proposal deadline. For example, township libraries, if they are formed by petition, and that petition is submitted to the clerk, and after the petition is submitted, the ballot proposal is submitted to the county clerk. So again, be very sure that you've got the accurate deadline. Make sure you have plenty of time before your millage language is due to get all this information worked out. Make sure you have a written resolution that you can submit to the county to show that your public body council board has approved it. For district libraries, if you are a district library that has a school district as one of your participating members, you actually have to give your resolution to what they call the school district election coordinator. In many cases, that school district election coordinator has delegated all of his or her duties to the county clerk, so often it's just a kind of a form over substance, but the District Library Establishment Act does require you to submit it to the school district election coordinator, so make sure, even if it's a belt and suspenders approach, that you submit it both to the county clerk and the school district election coordinator. So if you have any questions on the ballot language or anything I've said, please feel free to post them or to send me an email. Otherwise, I am going to turn the presentation over to Laura to discuss the marketing of this and the application of the Michigan Campaign Finance Act.
Thanks, Ann. Bear with us as we move on and switch subjects here to talk a little bit more about marketing your millage. It can be very exciting to have a proposal out there, and you might be eager knowing what good the passage of the millage could do to put the word out there, but you have to be very careful. The Michigan campaign finance laws do apply to public body millage elections. So this slide before you gives kind of a big picture overview of some of the issues, and then we're going to go into a little bit more detail. But big picture, you've got to be careful that you're not using public funds or resources to campaign for votes or to say, vote yes for the library, for the new library building, for the library millage. And it's important to have your attorney review those materials for the reasons we're going to get into momentarily. And kind of a side note before we get into that, some public bodies like libraries also have to be careful as they are working with people who are campaigning for millages not to give out information that would violate patrons' privacy, which is protected under the Library Privacy Act. Okay, we're going to move into some of the details on the law. Section 57, which many of you may be familiar with, is the important section for public bodies and their employees to pay attention to when it comes to millage campaigns. Section 57 prohibits using public funds, and it basically says prohibits them from using public funds to contribute to a campaign. And you might think of that in a traditional way of making a contribution, but contribute is actually much broader than that. It is really using the public funds in any way to promote or encourage a vote either way on the campaign. Now, Section 57 does allow the production or dissemination of factual information about issues relevant to the function of the public body. So this is where you can get into a difficult situation, especially if you're a public body that distributes a newsletter or regular emails to the public or things like that, because you want to provide information about the upcoming millage election, but you have to be careful not to cross this line where you're promoting a particular vote on the ballot proposal. So it might be factual to say, if you're a library and you have a library ballot question out there, it's factual to say this is what it costs to fund the library, you know, things that are definite, but you cross that line when you start talking about what this money could do for the library and that this library can help kids learn how to read, and that is all very genuine, and you may certainly see it as factual, but it's not really a discernible fact. It gets more into that persuasive or promotional or aspirational area that the law really says you can't do with public funds. So if you're going to be putting that information about a ballot proposal out there, it's very important to have your attorney review that first, and we do that frequently for clients to review their newsletters or their frequently asked questions about a ballot proposal to make sure that it doesn't go into that prohibited area. And it's a fuzzy line. It's not easy to determine, but after you look at enough of it, you can kind of get a sense for what falls under the lawful factual side and what falls into that prohibited promotional area. And it's important to make sure you're complying with that because violating it is a misdemeanor. So there's potentially some serious penalties out there for using public funds in a way that the Campaign Finance Act prohibits. So public employees often have to be careful about what they're doing, even if they believe they're just expressing their own views. Because of their position as an employee of a township or a library or a city or a school or wherever they're at, it can certainly look like they're expressing those political views on behalf of their employer, the public body. So the law prohibits those employees from expressing their views and distributing that information during their working hours, and also using public materials or resources to promote that. So there's two parts of that. There's the working hours and there's the using the public resources to do that. And employees should be, and this is, I should know, employees without policy making authority should refrain from engaging in that kind of work during their working hours or at any time using public resources. So you want to watch out for coming in after hours to use the township hall photocopier or paper, things like that, or computer network. And because public bodies are prohibited from using public funds to promote campaigns, you also got to be careful not to use public funds to purchase things that would be promotional, like vote yes or vote for the township hall or fire department. And where you can get into trouble is if the township receives money in the form of a gift or donation and then thinks, well, if I use that money to buy these things, that's not really public money, so I can use that to promote this campaign. No. If it's money of the public body, it's public funds, and it's that public funds is not limited to tax revenue or the traditional sources of funding. It includes any of those public funds. So there's another area where if you're not careful, you can get into some trouble. Another area to watch out for is how the public facility like the township hall or the library is used by people outside of employees using it to promote a campaign. So it's okay to let the Vote Yes committee use Township Hall as long as it's also okay for the Vote No committee to use Township Hall. And they have to be allowed to do that on exactly the same terms, and they need to be provided with exactly the same information and opportunities. You can't provide more, be a lot more flexible with one or provide different information to one than you do to the other. So it's important to treat them equally and provide that equal opportunity. All right, so you've probably heard or seen some things in the last few months, and if you followed our blog and our newsletters, we've written about it a fair amount with some recent changes to the Michigan Campaign Finance Act that changed Section 57. We've talked about these restrictions, and now there's more restrictions. So Governor Snyder signed this into law over the objections of every major public association, Michigan Township Association, Michigan Municipal League, Michigan Library Association, Michigan Association of School Boards. Everyone uniformly and publicly and vocally opposed the adoption of this new law, but nonetheless it went through. And what it provides is that a public body or a person acting for a public body shall not, during the period 60 days before an election in which a local ballot question appears on a ballot, use public funds or resources for a communication by means of radio, television, mass mailing, or pre-recorded telephone message if that communication references a local ballot question and is targeted to the relevant electorate where the local ballot question appears on the ballot. There is an exception that says this does not apply to an election official in the performance of his or her duties under the election law. But this is very broad language that essentially prohibits any kind of mass communication that references a local ballot question. So you can understand why this would cause a lot of concern for public bodies, particularly those who address local ballot proposals in their newsletters or those bulletins. It's been described by some as a gag law, effectively prohibiting any communication about it during that period before the election. Now, when the law was adopted, Governor Snyder issued what's called a signing letter, which is not binding. It's basically the governor's opinion about how the law ought to be interpreted, but it doesn't have the force or effect of law. And his signing language suggests, or signing letter suggested that this new law would only apply when the local government was trying to influence voters. But in signing it, he actually asked the legislature to amend it, saying, although I'm signing this into law, I think it ought to be rewritten. And this, again, prompted some public outcry from groups like the Michigan Township Association requesting or imploring the legislature to amend it. There is legislation pending to repeal the new law, and that was introduced within weeks of it taking effect. But more relevantly, there was a federal lawsuit filed shortly after the in January, shortly after it was signed, by several municipalities and school districts seeking a determination that those new amendments to Section 57 are unconstitutional and seeking an injunction barring enforcement of the law. And they sought what's called a preliminary injunction, asking the court for some immediate injunctive relief even before the court really hears the case. And the court did that. On February 5th, the United States District Court for the Eastern District of Michigan entered an opinion and order that granted the schools and the municipalities' motion for a preliminary injunction, and found in doing that those plaintiffs, the public bodies, demonstrated a strong likelihood that they're going to succeed on their claim that Section 57, the amendments, are unconstitutionally vague and therefore void. So the court really issued some strong language in that, suggesting that it really has serious doubts about the constitutionality of those new amendments. So for now, because there's that injunction, the state of Michigan and the Secretary of State are prohibited from enforcing those amendments until further order of the court. So if there were a communication during those 60 days, the state could not do anything about it while that injunction is in effect, which is obviously very important for all of you who are working on your pre-campaign communications at this time. and that case is still ongoing. So the possibility is down the road, the court could find in favor of the state, in which case the law could be found to be valid, or the court could strike down the law. All right, so if you really want to be promoting a campaign, you ought not do it in your capacity as a public body or a public employee, but rather look at forming a ballot question committee. If you have a group that intends to spend over $500, you should form a ballot question committee in accordance with the Michigan Campaign Finance Act. So that's going to create an entity that's completely separate and independent from the public body, which then takes you out of all of these restrictions. And then you can do things like say, vote yes for this. So it might be like Friends of the Library that could assist in forming a ballot question committee. And then you, again, get away from those restrictions and can make sure you're doing it in conformance with the Michigan Campaign Finance Act. All right, well, that brings us to the conclusion of our presentation today. We appreciate everyone being here. We do look forward to receiving your questions. Feel free to email Ann, me, or both of us, and we'll be sure to get back to you. Thanks, and have a great afternoon.